So we talk about the qualifications and disqualifications of directors. The Companies Act does not lay down any academic or shareholding qualifications for a director. And there's a widespread misconception that a director must necessarily be a shareholder of the company. But unless the articles provide otherwise, a director need not be a shareholder of the company. But financial prudence is that you as a director, you must have a stake in this company because you need to be actively involved. You want to make it work. You want to make it be successful. And how do you make something successful if you're not sharing in the profits as a shareholder? So the articles normally provide that a director will have certain shares for that company. So you remember the Companies Act is not the one saying that a director must be a shareholder, but the articles of a specific company will more or less provide for such an arrangement. This is because of the financial prudence, where you have that desire to see this company succeed. And if the articles contain a provision that the qualification of a director shall be the holding of a certain number of shares, then all the directors must hold that number of shares. There's no exception. What the articles provide is what will be done. And the articles also generally permit directors some time within they can acquire these shares, but it must not exceed 2 months. So what the articles provide that the directors own shares, it only gives them a time frame of 2 months. You're given a grace period of 2 months for you to acquire the shares that are prescribed by the articles in order for you to be appointed as a director. So where you don't purchase them, you cease to be a director automatically. There's no option of if. It's either you do or you don't. So when you don't, you're no longer a director for the company. And a director who vacates office for failure to acquire the share qualifications, you're liable for a penalty for every day that you continue to act as a director after the said period. This is provided for, the penalty will be provided for and agreed upon. But the minute you refuse to acquire these qualification shares and you keep acting on behalf of the company, then you can be sued. And the act specifically provides you being liable for a specific amount of money. So we talk of every director required by the articles to hold the specified qualifications and who's not already qualified to obtain the qualifications within 2 months. And we have said you vacate. Continuing to do so, you attract a penalty. So in Ivan Arthur Camps, the respondent, in his capacity as a director of a company, had been charged with several offenses under the Companies Act. Although the directors had, under Article 96 of the Companies Articles of Association, duly appointed him to be a director, and he had acted as such, he had never acquired the required share for qualification. But in a statutory return, subsequent to his appointment, he was shown as a director. So the magistrate held that the respondent had never possessed or acquired his qualifying share, so his appointment was invalid, and there was no case for him to answer. And the respondent was never a de facto director. And in the event that a de facto director was not criminally liable as a director for offenses under the Companies Act. So this case was appealed, but the appeal was dismissed. The court holding that a de facto director was not liable for criminal offenses. On further appeal, it was submitted and the respondent was validly appointed as a de jure director, and therefore he was a de facto director, and a de facto director was criminally liable. So the court in R versus Camps held that the word director includes a de facto director unless the context otherwise requires. And looking at the mischief at which the sections in question aimed, then such a person whose conduct should be subject to the section is a person who has been duly appointed as a director. So what this case to us, what it means that if you don't acquire the prescribed shares by the articles of association and you continue acting in your capacity, you are criminally liable for the acts that you commit, for any contract that you enter into the company, knowing full well that you are not a director as per the articles of association. So for the purposes of the acts you commit, you are deemed a director. You cannot detach yourself from what you have done. We talk about, and for the age, if the articles provide otherwise, we again, you remember we read the act in conjunction with the articles. The articles guide the member to the company. So what the articles provide will more or less take, is what will be done. So when do we disqualify directors? So a director will be disqualified if, one, he is adjudged to be of unsound mind. This means he has no capacity to enter into any agreement. He has no capacity to bind the company for any contract, for any service. He has no capacity to act on his own behalf. Therefore, that person is automatically disqualified. You see, under the law of persons, if someone is of unsound mind and he has been defined as such, the capabilities of this person are put in question. And once your capabilities are put in question, whether you're able to differentiate between right and wrong, and whether you are aware of what your actions actually mean, then you are protected from making decisions that may harm you or harm others that you are relating with. So where an individual is to be adjudged that he is not able to make decisions that make sense, that make that relate to what is happening, then that person is disqualified as a director. We talked about the element of someone showing up for the work they've been given. And where you're absent for 6 months, you do not appear for these meetings for 6 months, then you're not taking part, you're not doing the company a service that you were intended to do. So for that, you will be disqualified. So where a person is an undischarged bankrupt, insolvent, this is where you're not able to meet your day-to-day finances. If you're not able to cover your debts, we talked about a director being a person we expect to guide the company. And if you are not able to do this on your own businesses, then you'll be disqualified as a director. So where someone has been convicted of an offense to more than 6 months, you've been in prison, and 5 years have not elapsed from the date of expiry of the sentence, you will be disqualified. You are not the face of the company. The board of directors basically is what the company, you see, the shareholders will be in the background, having delegated the authority to the directors to run the business from day to day. So whoever is representing the company in meetings, whoever is announcing their annual reports, whoever is advising the company cannot be one who's convicted. It unfortunately brings a negative report to the company, on the company. And you're also disqualified if you fail to pay any call on your shares for 6 months. Remember, the articles want the directors to own shares so that the directors are able to work hard to make sure the company is making profits. So when you've been allocated shares by the articles of association, you are given 2 months. You remember, the time period is 2 months for you to pay up. When you're not able to do that, you have extended up to 6 months, then you're disqualified as a director. Where you have been found guilty of fraud in relation to the company or any breach of duty to the company, we said a director acts either as an agent, either as a trustee, and as a managing partner. So where you are acting in the interest not for the company, you will be disqualified. Where you engage in activities that put the company at risk, where you engage in activities that seek to defraud the company, you're automatically disqualified to be a director. We talked about the age limit between 21 and 70, unless the articles provide otherwise. So if you're under the age of 21, you will be disqualified. If you're over the age of 70, according to the Companies Act, you will be disqualified. The articles provide otherwise. They must do so in accordance with the law, and they will guide us on how to go from there. So where you are an undischarged bankrupt and you continue to be a director, Section 188 says that if you continue to do that without the leave of the court, you're liable to imprisonment. The period will be set by a court of law.